For a person to possess, consume, or purchase spirituous beverages, they must be 21 years of age or older. In order for a person to sell or serve spirituous liquor, the age requirements are different and are as follows. For an on-sale premises, the legal age to sell, serve alcohol is 18. Anyone under the age of 18 cannot handle spirituous liquors, but they can work in the capacity of a busser, dishwasher, cook, etc., as long as they are a minimum of 16 years old and are being supervised by a person who is 18 years of age or older. If the establishment is restricted to persons 21 years of age or older, the underage employees have to leave immediately after they clock out. To sell at an off-premises location, the legal age is 18. However, for an establishment that primarily sells items other than spirituous liquor, the legal age to sell is 16. However, they must be supervised by a person who is on the premises and is a minimum of 18 years of age or older. The legal age for an employee to make deliveries off premises is 21. There are restrictions that must be adhered to when delivery of spirituous liquor purchased at an off-sale licensed premises is to be delivered. The delivery can only be made during legal hours of sale and service of alcohol. The person receiving the liquor must be 21 years of age or older, not obviously intoxicated or disorderly, and the delivery cannot be made to a premises that is licensed to sell spirituous liquor. A record of delivery must be completed and kept on file for 2 years. Now let's discuss underage persons, customers, who can be in a bar. A bar is defined as an establishment with the primary purpose of sale and consumption of liquor. That would be ARS 4-244-22A. Aside from an employee who is 16 years of age or older, persons under the age of 21 may be in a bar under the following circumstances only: when he or she is with a parent, legal guardian, or spouse of legal age. An on-duty employee who is at least 18 years of age may also be in the bar. Members of the military and military veterans that are underage are allowed to enter such areas unaccompanied if the establishment is a club as defined by ARS 4-1017A. While underage individuals are allowed on the premises under such circumstances, they are still not allowed to consume, possess, or buy alcoholic beverages. A side note is this: a customer of any age may purchase, be served, consume, and/or possess a non-alcoholic beer. Under no circumstances may an underage person consume, purchase, or possess an alcoholic beverage. A licensed premises may construct a physical barrier to completely separate areas allowed to underage persons from areas limited to persons of age, such as a lounge. The limitations for who can be in a premises operating as a restaurant, its primary focus is to serve food, can change at any moment from an area allowed to underage persons to becoming a bar. This can result when the majority of the customers are drinking and not eating, even if it is before 10 p.m. If this happens, underage persons cannot be in the premises unless they are accompanied by a parent, legal guardian, or spouse of legal age. When spirituous liquor is purchased by a member of the general public, the liquor must be paid for at the time of the sale, although it is okay for a tab to be run until they close out their bill. But the tab must be paid before they leave because credit for spirituous liquor cannot be given to a customer and liquor cannot be given or traded for. However, private club members can be billed for their drinks consumed on the licensed premises, and registered gifts of a motel or hotel can have spirituous liquor billed to their room. Vending machines are not allowed to distribute alcohol. Also, no process or gases may be used to transform alcohol into a vapor state that is then consumable by inhalation. Spirituous liquor must be sold from its original container. In other words, you cannot marry bottles of alcohol, pouring from one light container to another. You cannot pour from a bottle that is marked as a different brand than was actually being poured, as well as all beer taps have to be marked as the beer drawn from, and the markings on the tap has to be visible to the customer. Any alcohol sold at an off-sale premises has to be in an unbroken container and cannot be consumed on the premises. If you see the beverage being consumed in the parking lot, you are required to stop the action. Be sure to document what happened in the logbook. You also cannot allow a customer to take an open spirituous beverage from an on-sale licensed premises. It is illegal for spirituous liquor to be removed from a licensed premises unless it is an unbroken package. A broken package is defined as any container of spirituous liquor on which the United States tax seal has been broken or removed, or from which the cap, cork, or seal placed thereupon by the manufacturer has been removed. If the customer is insistent on taking the drink, remind them they could be charged with an open container violation. Remember, This does not apply if the guest is transporting the beverage across an area to the licensed premises that is not contiguous to the remainder of the premises. At a non-sale licensed premises, in the event where a guest orders a bottle of wine and doesn't finish it, they can take it home with them as long as they consumed a meal on the premises and they are not intoxicated, in which case the unfinished wine would need to be disposed of. The bottle must be resealed in some way, and if a cork is used, it must be flush with the bottle. What we suggest is this. Mark the bottle where the wine level is and date it. Put the bottle in a bag and staple the bag shut with a receipt showing the meal they had with the wine. Ask them to put the wine in the trunk of their car or the farthest distance away from them, as long as it is behind the furthest wheel back from the passenger. Also, write in your logbook what kind of wine it was and where the wine level was. If the guest decides to finish the wine before they get home and something bad happens, you can prove they drank the wine after they left your premises. A popular way to purchase beer is by the growler. A growler can be purchased by a customer from the establishment if the establishment has the correct license. The beer has to be poured into a clean glass container that has a maximum capacity of not more than 1 gallon and cannot be consumed on the premises. The beer must be poured from a tap by either the licensee or an employee at the time of the sale. The container has to be sealed with a plastic adhesive and it must display a government warning label. The dispensing of the beer cannot be at a drive-thru or walk-up service window. There are 17 different liquor licenses available in Arizona. Each license has different privileges because you, as a seller of spirituous liquor, are required to know the laws of selling and serving alcohol, and you all work in different types of establishments. We have included all 17 licenses in the course manual as well as in this program. Ask your manager what series of license they hold so you can be aware of the license specifics you need to know for the operation of where you're working at. The definition of a licensed premises is this. Premises or licensed premises means that area from which the licensee is authorized to sell, dispense, or serve spirituous liquors under the provision of the license. Premises or licensed premises include a patio that is not contiguous to the remainder of the premises or licensed premises. If the patio is separated from the remainder of the premises or licensed premises by a public or private walkway or driveway not to exceed 30 feet. Subject to rules, the director may adopt to establish criteria for non-contiguous premises. Please read through the following series of licenses and their definitions.